back during the time of our founding, when people, meaning the founding fathers, thought there were dangers to attending places of worship, they actually required people to bring guns. In contrast to that, New York State, after NYSERDA versus Bruin was decided in 2022, tried to ban guns in churches and synagogues and the like. What happened? Well, the Second Circuit Court of Appeals just issued a major ruling on this. We have to break it down as to what it all means. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxer Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say I've been nominated for two 2024 Gundy Awards, one for the top male influencer in the Second Amendment community, and also for one of the top voices of the Second Amendment. I am honored and proud to have received these nominations. All right, folks, so we've already done a couple videos about the United States Court of Appeals for the Second Circuit out of New York City. They're ruling in the Antonyuk case, which is really 4 cases that have been brought together and been argued and issued a decision in tandem with one another. And there's one specific component I haven't dwelled on just yet, but I want to do it here with a standalone video, and that is, what did the U.S. Court of Appeals do with respect to places of worship, churches and synagogues and the like? Obviously, with what happened on October 7th, people are very sensitive, especially when it comes to synagogues and Jewish people who are at risk of terrorist attacks of what we saw in Israel. So it's a very sensitive topic. It was always a sensitive topic in my view, but it certainly is especially so right now. So I want to put this in the big picture. It's not that hard to understand, but you got to have a little historical context. So after June of 2022, the U.S. Supreme Court, of course, had issued their decision in NYSERDA versus Bruin. Thereafter, Kathy Hochul, the governor of New York, basically threw a hissy fit along with the other anti-gun politicians in that deep blue state, and they passed a law that imposed even greater gun control laws involving the licensing of people, as well as expanding the definition of what is a sensitive place, which is exactly what this channel predicted many months before NYSERDA versus Bruin was even issued. We've talked a lot about this, and as you know, a sensitive place, for the purposes of the Second Amendment, is a euphemism for a government-mandated gun-free zone. So what Kathy Hochul and the anti-gunners in New York State did is they passed a bunch of laws dealing with expanding the definition of sensitive places to cover almost the entire state. The good news is that the Second Circuit knocked out a major part of that law just yesterday or so. But there's another critical thing that occurred, and I want to specifically talk about this in detail, and that is that initially the state of New York banned guns in places of worship. And that includes churches and synagogues, obviously. Now, what happened was there was a series of lawsuits. The Antonyuk case, I think the Hardaway case, both initially asserted Second Amendment rights. That's the right of the people to keep and bear arms shall not be infringed. They asserted Second Amendment claims, arguing that by banning guns in places of worship, these were not traditional, or there's no historical analog laws that would suggest at the time of the founding that churches or places of worship could possibly be deemed, for the purpose of Second Amendment jurisprudence, to be a quote-unquote sensitive place. Keep in mind that in NYSERDA versus Bruin, the Supreme Court really said 2 critical things about quote-unquote sensitive places. The first one is that you simply cannot declare all of Manhattan or a city a sensitive place simply because there's a lot of people there. Plus, you have a police presence. That is not adequate. And furthermore, the U.S. Supreme Court in NYSERDA versus Bruin gave 3 specific examples that they considered to be presumptively sensitive places where you could have a government-mandated gun-free zone. Those were polling places, legislative assembly chambers, and courthouses. Those were the 3 things. They all have one thing in common. They all had comprehensive security at the time of the founding. Each of those places had armed security, whether in the form of bailiffs, sergeants at arms, or sheriffs and their deputies, depending on which of the 3. So what happened here, of course, is at the time of the founding, there is no such thing as a gun-free zone church or synagogue. In fact, it was just the opposite. At the time of the founding, when those churches or places of worship were viewed to be at risk, for example, of, let's say, Indian attacks, then guess what? Then many instances they would be required to bring guns to church in order to protect the congregants and the church services from a potential attack. Keep in mind that one of the most famous attacks, now this was not specifically a church, but it was a school, was the schoolmaster Enoch Brown in what is now known as Pennsylvania, and about 12 children were killed in a schoolhouse by marauding Indians. So there are instances where people viewed places to be particularly dangerous, and again, ultimately, in many instances, they were told to bring firearms to protect the community. Now, with this said, what happened getting back to the state of New York? So New York passed this law, and there were two lawsuits initially brought, the Anton case and the Hardaway case, saying there was Second Amendment violations, and basically they lost the injunction almost immediately because, again, there was no founding era history to ban guns in churches. As a result of that, New York State amended the law to moot out those particular claims, basically changing the law to say that the head of those churches or synagogues have the legal authority to designate a security team, which could be themselves or other congregants, whatever. But the bottom line is that the state of New York amended the law that no longer banned guns in churches. It gave the heads of those churches the permission to designate people who were, quote unquote, responsible for security. Now, with that said, there was a third case called the Spencer case. And I believe that case was in the Northern District of New York. I think the Anton and Hardaway cases, I recall, were in the Western District of New York. But I think the Spencer case was brought, and the Spencer case was also challenging the gun bans in churches and places of worship, except in that instance, the theory was not a Second Amendment right to keep and bear arms theory. It was a First Amendment theory, a free exercise theory. Keep in mind that under the First Amendment to the U.S. Constitution, there's various rights there, the right to free speech, but among other things, it includes the right to free exercise of one's religion, as well as no establishment of religion, i.e. no state-sponsored religion, if you will. You can't have the country be a Catholic country and have an official religion. But under the free exercise theory, the argument that the Spencer plaintiffs made was that this restriction on churches and congregants and the leadership violated the free exercise clause of the First Amendment because the leadership in those churches wanted to be able to allow people that came to those churches to bring firearms. And because, and this is a very creative theory, because the government, i.e. the state of New York, banned guns in churches and synagogues and places of worship, but they did not ban guns in other non-religious places, such as, let's say, stores or gas stations or whatever you want to call it. As a result of that, that became, according to the Spencer plaintiff's argument, an unfair, unconstitutional burden upon the right to free exercise of religion, because it was an example of the government treating worse places of worship than they were treating other places in the state of New York. And as a result of that, the judge in the Spencer case in the United States District Court for the Northern District of New York enjoined the state law on First Amendment free exercise clause grounds. This went up to the Second Circuit Court of Appeals, and indeed the Court of Appeals for the Second Circuit did indeed come out and agree that this violated the First Amendment's free exercise clause. And as a result of that, as I understand it, the way I would read this is that if you're able to attend the church and or synagogue that's specifically bound by or a party to this case, it sounds as if on First Amendment grounds, the Second Circuit is saying that anyone would be allowed to carry a firearm in that church and or synagogue to the extent that you're a party to this Spencer case that was just ruled on by the Second Circuit Court of Appeals. Obviously, you'll have to check, if you're in New York, you're going to have to check with your own lawyers and your own counsel about what you can and cannot do and how this decision affects you or doesn't. But what this does seem to indicate, though, is that if you want to bring a gun to a synagogue or a church, assuming that they are bound as a party to this decision, it seems like you might be able to now do that, even if you're not designated to be a a responsible for security person by the head of the church or the synagogue. But again, you're going to want to check with your own counsel before you do anything like that. We don't want to get anyone in trouble in the state of New York because they're so crazy. Who knows what they will do to gun owners in that state. They really do hate them. But anyway, that's essentially where we are. The bottom line is there is no Second Amendment ruling by the U.S. Court of Appeals for the Second Circuit because the Second Amendment issues were already mooted out because, again, the state had already changed the law to allow the plaintiffs in the Hardaway and Antonyuk case to essentially get the relief they wanted. And then the Spencer case, with respect to the free exercise clause, that was upheld by the Second Circuit. But it seems to me that may only apply to the relevant place of worship that was the party to the case, and they may not extend that to other people that are not part of the case. But it seems to me that's now opened up the door for other people to bring claims under the free exercise clause of the First Amendment after you consult this decision with your own counsel and your own situation. So anyway, that's kind of the update here on the places of worship issue and the Antonyuk case by the Second Circuit Court of Appeals. We'll see what happens next, but I'm guessing the state's not going to appeal and will just take its lumps on the places of religion, places of worship cases. But again, only time will tell. All right, I hope you learned something here today at the Four Boxes Diner. Please subscribe and share this video. Don't forget to follow me on X at Four Boxes Diner, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.